Recording in progress.
Okay, we'll call to order the March 6th, 2024 regular meeting of APCHA. First item on the agenda is the roll call.
Okay. Allison?
Present.
Peter?
Present.
John Doyle?
Here.
John Ward?
Present.
Carson?
Here.
Kelly? Here. Francie?
I'm here.
Thank you.
Okay. I don't have any agenda amendments, so we'll move to public comment. Just quickly, Bethany, Diane, can you hear us? Can one of you just unmute and let us know if you can hear us?
I can hear you.
Thank you.
What happened?
Okay, we'll move to public comment. So we've got someone here in the room. So public comment. Ms. Silvino, we do have an item on the agenda regarding your case. The record is closed on this, so just for your knowledge, nothing that is said can be considered by the board, and the board won't be responding. So we've got a 3-minute time limit, so if you could keep to that, we'd appreciate it.
Thank you. Thank you for this 3 minutes to shed light on the appeal for my case. There were a few things that were overlooked. You said that John was not qualified, but he was qualified until the divorce. I have 3 documents stating that he was qualified. One from Cindy Christensen. It's on the transcript, and the mixed order says that he has pay stubs and invoices good until we were divorced. Why were we divorced? Because of human safety, of autonomy, abuse. I have a restraining order, a copy of it. I also have his police statement where he has 6 other permanent restraining orders for other women. I have mixed orders, first order and second order that he wrote after the meetings with APCHA, September 26 and October 11. They're very different. I hope you have a chance to look at them and some corrections to the record. There's 2 letters from Response, which is an organization for domestic violence in the Valley that I've been working with to help with the trauma from all of it. And they wrote letters to you. Matt Gillen was supposed to forward them to the board. I'm not sure if you got them or not, but they're in the packet as well. And then there's 3 laws of protection for this isolated issue: HUD, Women Against Domestic Violence, and Fair Housing Act. Also attached, you said that I was hiding the fact that he was not here. That's not true. I have a letter to Bethany and even a reply stating that we were getting a divorce, and I hope that's 3 minutes. Here's packets for the lawyer.
Cannot accept anything.
Well,
further.
I mean, it's just
You can
backing up what I'm saying, and
You
it's
can
the
leave
truth.
them with the secretary here, but you can't ask the board to consider matters
Okay.
when the record's closed.
I didn't. There was really a lack of time last time, and there was so much being said. And as your board said earlier, the evidence was 600 pages long, and it was a lot to go through. And there were a lot of things that were really big that I felt were oversighted. And so thank you for giving me a voice. And this really affects my entire life. I've been here for 15 years. I love this place, and I don't want to be displaced. And it's an issue of safety. So please consider it before you make a decision. Please. And you just lost a case, according to Mick, and they stated, wasting taxpayers' dollars, and I don't want to waste any more time and effort either. And if you could just maybe take a look at it, I think we could maybe just move on with our lives. It's been 2 years now, and it just feels like re-traumatizing all the time, and I'm ready to move forward. Please take a consideration on this. I really would appreciate it.
Thanks for coming in.
Thank you.
Is there any other public comment? If you're online, you can go ahead and unmute yourself. Going once. Hearing none, we will move to the Board of Directors comments, and we are all here in person. So we'll start with Allison.
Greetings, fellow APCHA board members. I was gone for the last meeting due to travel, so I think this did come up. I saw it in the minutes, but I wanted to address the joint BOCC city council meeting regarding APCHA, which I was able to watch. And I think my takeaways are that there was lots of good discussion. I feel a little odd about, I guess, the order of how that discussion went, and that it was things that the board has discussed already. It was things that we've researched and sent surveys about already. There was comments about these meetings not really being worthwhile attending. And I thought it undermined the volunteer citizen aspect of this board, which, as the IGA put together, should be like the power vote and the could be the deciding factor even without elected officials on the same side as part of the makeup. And so I do hope that those discussions can happen with staff to find out a little more context before saying things have never happened, or here at the board level, or a joint BOCC City Council APCHA discussion if we do all have things to say about the most important issue that we have here in the Valley. So that was my takeaway from that, and besides that, I don't have anything at this time.
Thanks, Allison. Peter?
No comments at this time.
John?
None tonight, thanks.
John Ward?
I have none at this time.
Francie?
No, I have nothing, thanks.
Kelly?
You may have read in the papers, the county has agreed to contribute somewhere around $2 million toward the buy-down program for the West Mountain Regional Housing Coalition to kick that off. This will spark a fundraising effort throughout the community, just heads up, to governments and employers that perhaps may want to also contribute to the fund for similar purpose. I sit on the funding subcommittee of that housing coalition, and so I just thought I would let you know the progress of that going on. I should get my act together and come back to you guys with some more legislative updates, but there's some interesting legislation related to construction defect lawsuits that is being contemplated in the legislature right now, in which, we know have some experience here in Aspen and in APCHA inventory. Some of those are looking at studies to try and figure out what is the, essentially, is construction defect lawsuits a contributing factor to the decline in condo development in Colorado, or are there other causes? And what do other states do? What are best practices for construction defect laws, et cetera? I just wanted to flag that for you all.
Well, I know strategies have changed with developers, turned them into apartments for 8 years. That's part of it. My question...
Though there's been some studies that show that Colorado's laws aren't particularly, egregious compared to other states' laws, and yet...
I think the change highlighted an issue and made developers and investors think and not want to be on the hook for defects after a period of time, so that's why they changed to apartments.
Some of the argument is, are there more real estate investment trusts that are trying to get longer return on their dollar that a ordinary condo developer wouldn't see?
Well, I mean, that's the big money too, right?
Interesting.
I wanted to know, go back to your first comment on the buy-down program. Is that going to look like the Indeed program in Vail a little bit? And $2 million feels like a spit.
So yes, I mean, the way that it's being structured is prices up to $1.5 million. So a sale up to $1.5 million, purchase up to $1.5 million. A qualified worker in the Valley could apply to this program to get 30% of that covered, to turn it a free market into a deed restricted RO property.
And then does it look like deed restricted, you just got to work in the Valley? I mean, it's a little bit like Aspen Village where sales become... Yeah, it has to be your primary residency. You can't own other residential property anywhere. There's the 3% appreciation cap. So you cap you agree to a cap the appreciation. Yeah. See, the Indeed program doesn't have a cap. It's just got to be work in the Vail Valley. And then the prices go down
the further down valley. So I think from like Basalt to Glenwood, it's 1.2 million is the max purchase price, and then down to Parachute is 800,000.
Okay.
They anticipate being able to do about 10 buy downs with that, and will be soliciting interest from others in the valley.
Great. Only item I had was just I saw the article in the paper just with the update on the audit program, 95% in compliance through the first 79 or whatever the number was. I thought that was a great article, and certainly I think you know, an upside surprise from the standpoint of 95% compliance on a random audit.
It's even better than the headline because the 5% are not out of compliance. We're just still working on the unresolved. So yeah.
Well, that was, there was a comment or a statement in there in the article that kind of made me wonder. So it was about getting compliance, or, I mean, so what are the issues that were not resolved? I mean, because there's things you're just never going to get into compliance.
The writer of the article wanted to get into that, and we declined to get into individual cases at this time. So Jackie's going to be coming back closer to a year, when we've been running the program closer to a year, and she'll come back for a formal presentation to the board. And I think at that time we can bring up some of the more aggregated problems we've seen, if indeed there are any. If that works.
Well, but I mean, shouldn't we know what the issues are with getting into compliance?
We don't have people who aren't out of compliance. We're still going back and forth with them on some issues. So I don't think we're even at a point where we can say
why is
that
it
they're out of
secret that we
compliance.
don't know what they are?
Sometimes it's as simple as they've changed their P.O. box and we just haven't been able to get the notice to them yet. So we're not even at the compliance discussion with some of them. We sent a letter to what we had on file. It comes back by the time it gets returned. So some of them we're just trying to get to we don't even have a substantive discussion yet.
And that's only 4 cases, right?
Right.
Right.
As this audit's going on, and the article in the paper said it would be take 5 years to go through the 1,700 units.
Yeah, she did that math. I didn't. Yeah.
Okay. Home Trek is being populated with information on what industries the homeowners work in, how many retirees. Like, are we getting good information from this audit?
Peter, Home Trek is not doing that. Home Trek. That is
So we're not collecting that information.
No, Home Trek is not doing that. We look at people if they qualify, but we do not have a field in Home Trek which says where people work or what industry they're doing.
I think I would like to have that discussion with the board.
We can have that discussion, but that is not what Home Trek is doing now.
Carson, can we add that to an agenda?
We've talked about that before.
We've talked about that.
So we're not in an agreement to collect that information?
No.
Okay.
My question just becomes on, like, I wouldn't call it in compliance. It's more like we're trying to connect with people, right?
Right.
So it's not even get them in compliance because we don't know if they're in compliance. We're just trying to.
Unknown.
Yeah, that's why. Yeah, I think
they used the word unresolved, right? I mean, that was the word.
Yeah, there was a word.
That was the word we were pushing for her to use rather than out of compliance, and it was in there, but the headline didn't quite match up with the story, which often happens.
But a lot of times, John, information might be incomplete or not obvious what conclusions staff can draw from information at a particular point. So the investigation continues until you get a more solid understanding of the compliance question.
Okay.
But we will come back to you with a formal presentation on that.
That's it. So for me, so we'll move to Executive Director's comments. Matthew.
Hi. So we talked about, I was going to highlight the story in the paper, which I thought was very good, and also want to continue shout out to Carson for his articles in the paper, and he's got another one in the works, and those are really having a great impact. And the only other thing I really have as comparison with last time, where I had a lot of stuff, is the reserve study RFP. We are ready, like right now, to start reaching out to HOAs to get them signed up. We've been doing a lot of work with the vendor, and so we'll be reaching out to them starting this week. And we also sat down with City of Aspen Communications today, and we have a pretty involved rollout program, both to make sure that the HOA presidents and treasurers know about it, and also that the community in general knows about it. So we'll be on social media, we'll be doing articles in the paper, and maybe even some paid advertising to make sure not only do we capture all the HOAs that want to participate in the reserve study, but also the community knows about this great effort that we're putting in to the benefit of APCHA and the community.
Have you had anybody reach out?
We've had quite a few people reach out.
Good.
On the word's out there, but we'll be doing the formal rollout now.
Perfect.
Can you remind me, that's just a courtesy. It's not a swap, like we'll do the study. You can participate in the study if.
We have not, we have not, we can't tie it to any future actions by the city, county, or APCHA. So yes, right now it is a courtesy.
Lovely.
Because there are some, we have had a few, I don't say complaints, but there are some HOAs who are doing the right thing on their own, and they have said, hey, what about us? And we're like, oh, sorry. So, if you're not participating in this program, it does not necessarily mean that you haven't been doing the right thing anyway. So it would be hard to tie it to a future action.
Okay.
And that's all I have.
Thank you. Cindy?
We do have a few things on sale, or that are going to come up for sale on Friday. One of them is an RO single-family home at Burlingame 2. The open house for that home will be next Wednesday, so if you are in Category 5 and RO households will have a priority for that. I believe it is a 4-bedroom single-family home. So again, the open house will be next Wednesday from, I believe, 4 to 5:30. And I know that there's another one that's coming up. I believe it's another centennial. So again, it's really important to sign up for notifications for rentals and for ownership, because we are having quite a bit of units coming up for sale right now. Thank you.
Thank you, Cindy. Okay, we'll move to the consent calendar. We have 2 items, minutes of February 21st, and then approval of resolution number 3. Do we want to split those out or approve with a single motion?
Do we have to split them out to ask questions?
I would.
Yes.
I'll move to approve the minutes.
Okay.
Second.
Second for the minutes. Any discussion or corrections on the minutes? If not, it's a roll call vote.
Okay. Kelly?
Yes.
Carson?
Yes.
John Ward?
Aye.
John Doyle?
Yes.
And Allison?
I'll abstain.
Okay.
Okay, and then we have the approval of resolution number 3, series 2024, appropriating funds from the 632 Development Fund up to $315,000 for the construction of a new home at 213 Woody Creek Park Subdivision.
I'll move to approve that.
Have discussion after a motion has been.
Yeah,
made.
that's typically a second, then have discussion, right?
Then you
I'll
have
second.
to-
Okay. Allison?
I just wanted a reminder what the cap of what we can sell it for after, like, this is something we think we're getting recouped essentially.
Yeah, we're going to we're planning to get all our money back, if not a little bit more. I can't remember the
And I
actual.
thought it was in the memo.
So we are a
Sorry,
developer.
I just looked, but I might have overlooked it.
It's for Category 5 single-family home is $653,000, something like that. And if it doesn't get done until 2025, more than likely we'll have another increase that we can work up to. Right now we're below that with all the costs that we've had, plus the cost of the home that they have provided us. So right now we're below that. But we are going to try to at least break even. We're going to take into consideration all the past HOA dues, the utilities that we've already paid. If we've had to work legally on that, we're trying to make it to where we do break even and still stay under that maximum sales price.
So the cost of the unit or the manufactured home is $298?
Right.
What was the lot? Did we already buy the lot?
Yeah, that's in there.
It was 300 and,
Yeah, this was this is the
270,
follow-up to an enforcement case,
279.
right?
well, no, this was a death in the family. This one
Oh,
was.
this was the next door.
Right.
Okay.
Right.
We closed on the lot with APCHA funds already.
Yes. You
So
guys
now
approved
we're
the
at-
APCHA funds already.
Okay, so now we're at just under 600
Right.
all in. And we're gonna sell it for that or more.
Right.
What's the category cap?
It's category 5, single-family home, which is around 650, something like that, or might be a little bit more.
Okay. There's no interest carry or contingency in this budget?
There's.
Spoken like a true banker. Any other questions or discussion?
Yeah,
Francie?
I just wanted to say, I noticed it's Clayton Homes building, and I just want to push again for Phoenix House. Clayton's Homes offices are in Tennessee. Phoenix House is in Grand Junction. I did go and visit them, and I think I told you about it 2.5 years ago or something like that. But they are really environmentally sound, and their prices are great. House is HAUS. And so I just recommend them when we're looking at modular homes. They are very innovative and right in Grand Junction.
This is modular, so it goes on
It's a
permanent
prefab.
foundation?
It's a they
Oh,
bring.
that's what I mean, we're gonna go on a permanent foundation with this
Exactly.
and-
Yeah, that's what theirs are too, and they don't do the foundation, you do the foundation, they arrive, and it's like, well, when I last talked to them, it was like 5 days from the time you ordered the house to when you got it. And the walls are, apparently this is used in Europe, the walls are made of like shredded wood and newspapers and stuff, so they're really dense and really high R rating, and it's just a really cool company. So I would recommend in the future to look at Phoenix House.
I want to add to that, I have an acquaintance who is building a Phoenix House in Stotts Mill down
Yeah,
south.
Stotts Mills, that's right.
They are very happy with it, and be interesting to get a tour of it.
Well, how committed are we to
We're under contract with them. And one of the reasons why we did go to Clayton is because they've done probably 4 or 5 homes already in that area. So they're very familiar with that whole process, and they've gone through it. So that's probably why we decided to stay with Clayton this time. But I'll do some research on Phoenix Homes.
It's good to have
as well.
options, but yeah.
We're not required to RFP or anything like that?
No.
We had multiple discussions with the city of Aspen.
Yeah, okay. Thank you, Francis.
Maybe we can
Maybe we
get
should have
tax
site
breaks
visit.
from Mesa County.
At Stotts Mills. That's
So
Stotts.
Phoenix House.
It's a really cool factory.
We'll go.
It's the last Stotts Mill lot sold today, by the way. So.
Maybe there would be some way to get tax breaks from Mesa County. I don't know, just throwing that out there.
Do they tax people over there?
I'm not sure. I mean, if we're helping grow a business in Mesa County.
Where's it located? Is it located in that, is this company located in that business park down there?
It is in a business park, yeah.
Down on
I don't
the
know
river-
if it's
river
the
park?
business park. I don't know the name of the business park, but it's in a business park.
I know we already moved, but how do we go back to voting time?
Any other discussion? If not, we have a motion
A second.
and a second. So it is a roll call vote.
Okay. I'm going to go the other way. Allison.
Yes.
John Doyle.
Yes.
John Ward.
Yes, ma'am.
Carson.
Yes.
Kelly.
Yes.
Thank you.
Okay, next item on the agenda is approval of resolution number 2, series of 2024, denying the appeal of Miriam Silvino of the notice of violation dated August 31st, 2023. So just a couple of housekeeping items here. Allison, you previously recused yourself from previous discussions. Do you want to do that today?
Yes, please.
Okay, so if you want to just head out into the lobby, we'll grab you when we're done here. And then Ward voted at the last meeting. He's out today sick, so John Doyle will be voting in Ward's absence. John has reviewed the record. John was at the February 7th and the February 21st meetings. Anything else, Tom?
Let me kick us off a little.
Well, real quick, because I was not part of the,
And I think you abstained from
I
the last
abstained.
one, so.
so I don't need to leave the room. I can sit and
Well,
listen to
that's
them.
kind of what we do, but yes, I think if you're abstaining, it kind of keeps the record from being muddled about whether you've had input into the decision, so,
I'm gonna
that's like
abstain.
Allison, I think you probably should.
You want me to leave the room? Okay, well, call me back in.
So, at the last meeting, the board directed staff to prepare a resolution of denial based upon a consensus that John Francis was one of the owners was in violation of both residency and employment requirements, and that was sufficient to constitute a violation of the co-owners jointly, and you directed a resolution denial to be prepared. I've done that without input from staff. I want to summarize what's in here, make sure the board fully understands it, answer any questions you have about it. Your decision is not yet final unless and until you approve a resolution. You are still free to affirm, modify, or uphold the appeal, because there's been no official decision at this point. These decisions are never easy. It's always difficult to terminate a lease or to terminate an ownership. APCHA, neither anyone on APCHA staff nor anyone on this board gets any personal benefit out of that or any personal gratification. This is about the integrity of the program, and more specifically, making sure that qualified people are in these units. When someone unqualified is forced to sell or give up a lease, that means that someone who is qualified will be given an opportunity to live there. And that person, of course, has to comply with the rules. So that's what it's about. And it's difficult on an emotional level, but it's part of what we do to keep the program functioning for the benefit of those who deserve to be in it and for the benefit of the taxpayers who subsidize it and expect us to enforce our rules. The resolution that you have in front of you is essentially just an elaboration on the primary basis that was articulated by the board directing that a resolution be prepared. And that is that John Francis, one of the co-owners, the record that was made at the hearing, well, preliminarily ahead of the NOV, and then at the hearing before the hearing officer, evidence was not provided that John Francis has resided in the unit in 2022 and 2023 for the 9 months per year that's required, or that he's worked the 1,500 hours per year that's required. In fact, Ms. Silvino's attorney conceded that those facts were true. The defense was essentially that Mr. Francis's violation could not be ascribed to her, and that if she was still in compliance individually, that was sufficient for the granting of the appeal. And I have cited in this draft resolution for you the various provisions of the regulations that show that that's not correct. The fundamental requirements of the deed restriction and the APCHA regulations are that both owners must maintain compliance throughout the period of ownership, and that if one is not in compliance, then the property has to be sold without regard to the individual compliance of the other person. One of the reasons for that is that we have multi-bedroom units, and of course minimum occupancy requirements apply to those, and it's essential that we not have that policy eroded by people signing up for units, getting approved as a couple, or either or couple or co-owners, then ownership changes immediately so you have a single owner, and the whole purpose of the minimum occupancy requirement is undercut. In addition, there's a policy of making sure, of course, that both owners comply, and that you don't use ownership or approved ownership to circumvent the lottery requirements that apply normally when a unit comes on the market. And in this case, it would be that the lottery would not be utilized for conveyance to Ms. Silvino in the manner proposed here, and that's certainly not consistent with the rules that I've cited in the draft resolution. So the findings are there. As I said, the factual aspects of Mr. Francis's violation are not contested. I have highlighted evidence in the record that supports that factual conclusion. There are issues that the hearing officer addressed that this resolution would not address, one being Ms. Silvino's individual compliance, because it's not necessary to reach that issue. And in fairness, the NOV did not cite her as not being individually in compliance. And there are other issues that I believe that we had direction from the board not to not to take jurisdiction over here, in particular the issue of domestic violence, which, if allegations are true, are serious, but the APCHA is not in the business of adjudicating that. We don't have evidence that APCHA or that there is anything legally that would come into play there. And perhaps most importantly, APCHA is, with respect to any disability of any kind, or in this case domestic violence, APCHA can still enforce its rules. The prohibition of the law on discrimination is that you can't discriminate against somebody because of their status as a member of a particular group, in this case those who are sexually or victims of domestic violence. The enforcement here is because of non-compliance with the underlying requirements of the deed restriction. And that deed restriction clearly requires sale of the unit in the event of a violation. So it's not related to that question. There was a question of, or an issue raised in the brief filed on Ms. Silvino's behalf about hearing officer McCarn having a conflict of interest. These are issues that have been raised in other cases, some of which have been considered. This issue has been considered by the local courts, and I have summarized in paragraph 10 here the reasons why Mr. Ireland's status as a resident of deed restricted affordable housing is not subject to a conflict of interest, just as with some members of this board. It is simply not a basis for a conflict. An individual who's in affordable housing might just as easily have more sympathy for somebody who's subject to enforcement as to enforcement at the hands of APCHA staff. So it's really not considered by, legally in any event, to be considered by as a basis for a conflict of interest. So that's a summary of what is in this resolution. I'm happy to answer questions. You can debate, discuss, affirm, as I say, reverse or modify what's contained within this document. Your decision.
Thank you, Tom. I'll just maybe, Kelly, go ahead. Go ahead.
I'm going to request some amendments to the exact language, but I have a question related to paragraph 8 under findings, page 5 of the resolution.
Paragraph 8, so that's conclusions in law.
So page 5 of the resolution, paragraph 8,
Yeah.
where it starts, the hearing officer's determination that the dissolution of the marriage triggered violations and obligation to sell the property was incorrect. I just want to understand if we need to say, you know, the APCHA board rejects this finding of the hearing officer, or, you know,
It says was incorrect, so I think that accomplishes it.
I know, but I don't know if our authorities here are to affirm, remand, or deny.
Right?
I don't know where incorrect falls in that.
Okay, so basic rule on appeals, and it's true in the courts as well. The decision being appealed from doesn't have to be correct about everything that's in it, in the underlying decision in order for an appeal to be upheld. The fundamental question is whether the record supports the outcome. And if the decision of the hearing officer has both, for example, has both valid and invalid reasons in it, the valid determinations are the one that count, if the appeal is being upheld. So the Court of Appeals in reviewing district court decisions the same way. They frequently say, well, we reject this decision by the district court, but they were correct in this other, on this other issue, and that's sufficient to uphold the appeal. And so that's sort of the essence of what's embodied in conclusion number 8. Also, what else did I put in, would I put in that category? That's the main one that I think. Oh, the other thing was whether Ms. Silvino herself was in violation. Mick Ireland, the hearing officer, made a determination that she was, but this resolution says that's beyond the scope of what was in the NOV, and it's not necessary for us to reach that issue.
Okay, that's fine, I'll accept that. I would prefer paragraph 11 on that same page to be simplified, and maybe just say Silvino asserts that a requirement for her to sell the property is discriminatory because she is a victim of domestic violence. I would like it to just say APCHA has no authority to determine if Silvino is a victim of domestic violence, and get rid of the rest of the
At your discretion, that's correct. At your discretion, that's.
Okay, that's why I thought this should get appealed to the court. These are not areas where I feel comfortable as an APCHA board member to make any decisions.
So that would be
about.
what's referred to here as the second.
Yeah, yep, so just the
Just
first,
that one.
yep, just have the first sentence, period, and then APCHA has no authority to determine, and have that sentence
Okay.
stand on its own, and delete everything else if that's acceptable to Carson and John.
I mean, I would just ask, is there any?
It's at your discretion to change that.
Okay. Thank you. John, do you have any thoughts on that?
I agree with Ellie's suggestion.
Okay, and then my sorry, go ahead, Carson.
So
I have
we're gonna strike everything after the first sentence.
Well,
then-
you're gonna keep the first sentence, and you're gonna keep the
And then we're gonna replace.
second reason only
Yes.
after that.
Just APCHA has no
Correct,
authority
yeah.
to determine.
So, there you go.
And then my final suggestion is number 3 in the order. I wonder if that should be moved into the section above it. Where
On
it's
what now?
So where it
Oh,
says.
that could be, you moved any, if you want to put it into the
Okay,
conclusions rather than in the order, that's fine.
Where's that?
so where
think
it
that makes
reads,
sense,
yeah,
yeah.
the board notes that Mr. Francis did not appeal the notice of violation as provided, and as provided there, and as provided in the deed restriction and APCHA regulations. To me, that sounds more like
Fine, so you can make that number
Finding
12.
instead of
number
something that
12 on the
happens.
preceding
Yeah.
page. Okay.
Thank you. And then I would just say, since I'm a little uncomfortable with assessing the penalties against Ms. Silvino, since the NOV was against John Francis.
That was my question.
Okay, well, that's up for debate by you. The decision of the hearing officer was that each individual was to pay this amount. So that's why it's in here because the direction was to affirm, but you still have the ability now to say you want to change that, the findings on the penalties that's your discretion.
I guess I wonder if the penalty is assessed against John Francis, and clearly we have no reason to think we're ever going to collect that. Does that then sort of protect against any future ability for him to enter back into APCHA inventory?
Well, the general rule is that, we have in the rules now what's called an ineligibility list, and you get on the ineligibility list if you're a violator. And in addition, if you owe money to APCHA, you're a violator, and you're not going to get back in, unless and until you pay your debt. On matters that aren't black and white, like payment of the debt, there are discretionary considerations that can be taken into account when one is put on the ineligibility list. But as I say, this, the assessment of penalties was included in the NOV. It was included in the ruling of the hearing officer, and the board directed a resolution upholding that ruling. That's why it's in here. You have discretion to make adjustments to the order as you choose.
Shouldn't they be on him?
Huh?
Shouldn't they be on him?
Okay,
I mean, if
so,
she
well, as I
refuses
said,
to sell, then that's a whole different
The assessment,
violation, right?
yeah, well, here's, okay. Mick,
I want to be very clean about this.
I understand, and you're good, it's good to bring this up. So, there's a contradiction in Mick's ruling in that he correctly said that he didn't have jurisdiction over John Francis because John Francis didn't appeal. That was accurate. And under the rules, if you don't appeal, the decision of the NOV becomes final at such time as the appeal period runs out. So that's what's essentially said in the number 3 we were just talking about. The assessment of penalties that Mick referred to against John Francis is really a gratuitous statement because it was already final as to him as a result of him not appealing the NOV. So it wasn't necessary to his decision. It's not necessary to your decision either because he's not here. And it's already a legally final determination as to John Francis. As of today, as a matter of law, he owes that money. Doesn't need to be addressed here. So the only discretionary question for you here is on as to whether or not and in what amounts you might want to impose the penalties that were assessed by the NOV and the hearing officer's ruling against Ms. Silvino.
Francie.
Yes, I was gonna ask that same question, why she was being fined, but it seems like we have a sort of a double-edged sword, like, she was living in the house, she was married to him, he leaves, so she loses her right to stay in the house because he didn't file his paperwork, and now she also has to be fined for what he's been found responsible. That seems like a double whammy to me, and I don't know. It just doesn't seem to make sense to me that she owes these fines when she's not allowed to keep the place in the first place. Like she doesn't have any interest in it. So why?
Well, she does. I mean, to be clear, it was understood when this deed restriction was signed what the obligations of both parties were commensurate and devolved to both parties to comply. There wasn't any ambiguity in that. And it wasn't just a failure to, meet a paper shuffle requirement here on John Francis's part. He moved out within months, left the country by admission, hasn't worked hardly at all since that deed restriction was signed. So it's not a technical issue, and when Ms. Silvino and John Francis signed up for this property together, and that's the only reason they could get it, right, was to agree that these are the requirements that you have to live with, right? I mean, otherwise we get in this situation where, okay, people sign up and they're married or they are co-owners, and then, what? If someone decides when they wake up the next morning that one of the owners is going to leave, should it be okay that one person gets ownership of the unit when that couldn't have happened in the first place? That's what the case is about. Now, there's a separate question for your, which is within your discretion, whether you feel that the requirement to sell is sufficient and that penalties shouldn't be imposed on Ms. Silvino. That's a legitimate exercise of your discretion to make that decision. And I'm not gonna tell you whether it's right or wrong. I can tell you that the NOV had the penalties in it, that was affirmed in the ruling, and now it's in front of you, but you have the discretion to adjust that if you want to.
So can I follow up with just one more question? So if it were a married couple that had lived in the place for like 5 years and one of them disappeared, that person, if it was a minimum of 2-person occupancy, would in fact also lose their right to stay in that home?
I'm not sure that's what the rules say. It's a hypothetical that we're not presented
Well, I
with
mean,
here.
why isn't she able to stay in the home if she qualifies?
Pardon me?
I'm assuming the reason she can't stay in the home is because they don't meet the occupancy
No, it
requirement?
was, well, there are
that was what you
multiple
said.
reasons as stated in the,
But I thought that was what you said when you
there
were
are
explaining.
multiple
Yeah,
reasons.
okay.
One is both owners have to be living in the unit and have to meet the employment requirements. And those are referred to in numerous different provisions that are cited here.
I'm just
There's
wondering what
a-
we would do with other
It's
divorces.
for a specific certain
Yeah.
period of time.
If you're married for 5 years.
And this is,
Oh, you have to be married for 5 years, that's what I
Or
was
I
asking.
think we need to be
Because-
careful
right.
here about getting outside the record.
Yeah.
Okay?
Yeah,
So you've
I
raised a
understand.
hypothetical, and, you know, that wasn't debated on the record.
Okay.
It's a different type of situation than we're faced with here,
Okay,
okay?
yeah. I just thought the 5-year thing was, okay, let's move on. No worries. Thank you.
Kelly.
I would propose that we strike the penalties and retain the requirement that the property be sold. And John Francis will be required to pay penalties anyway.
If and when he shows up.
Yeah.
Right. And I'm supportive of that. I mean, we're all volunteers, and this is without question, these appeals are the hardest part of my volunteer role on the board, is equally applying the rules to everyone and making sure that the rules apply to everyone or they apply to no one. I agree with you that I think that in this case, I think there are other cases where we looked at where I do feel that sale of the property and assessing a penalty is appropriate. In this instance, I think I'm supportive of waiving the fines for Ms. Silvino.
I agree with both of you. This is a really difficult position to be in, but I think we can show at least a little bit of compassion. So I support your suggestion.
All right. Any other?
I don't have any other changes.
All right. So then I would look for a motion to approve
Is
with
this a public hearing?
As amended?
Is this a public hearing?
No.
no.
No? Okay. Yeah, I'll move to approve, let me read it as written. The resolution of the APCHA board denying the appeal of Miriam Silvino of the notice of violation dated August 31st, 2023, with the amendments I've proposed and accepted by the board.
I'll second.
Okay. And it is a roll call vote.
Kelly,
Yes.
Carson,
Yes.
and John.
Yes.
Okay. So that concludes resolution number 2. The only remaining item is executive session. We'll just take a short break to get
Gotta have a motion.
Allison and John back in the room.
I'll make a motion to go into executive session. Hold on. Oh, sorry.
Yeah.
Got excited.
Anyone want to play with any Play-Doh while we sit here?
Is it edible?
Oh, God, it's just starting in my house. My daughter's 7, and it will not take hold of my house. It
When my
sticks to
youngest
everything.
son was 6 or something. We lived for a very short time in St. Louis. And he was quite a successful little model. And he was in
All right,
a
so-
television commercial for Slime on Saturday morning cartoons.
The only remaining item on the agenda is the executive session. There are no further items on the agenda after the executive session, and after the executive session is complete, the board will adjourn.
Yeah, no decision is gonna be made. We're not looking for a decision, it's just a discussion of this litigation.
Okay.
I'll move to go into executive session for a conference with APCHA attorney for the purpose of receiving legal advice under Colorado Revised Statutes, section 24-6-4024B, regarding case number 2022 CV 30094, Cameron McIntyre and Patricia Redfield McIntyre versus Aspen, Pitkin County Housing Authority.
Okay, I've got a motion from Kelly,
I'll second.
second from Allison.
Roll call. Allison?
Yes.
John Doyle?
Yes.
John Ward?
Sure.
Carson?
Yes.
Kelly?
Yes.
Okay, we're gonna go take a 5-minute break to
So you
clear the
paused it
room
before
and
you-
move into executive session.
For the record,
we're-
an executive session
Keep this.
that's undertaken for this purpose is not required to be recorded by the terms of the Colorado Open Meetings Law.
Thank you,
So
Tom.
the only thing you'll need to do after the executive session is record the motion to adjourn.
Do we need to invite Diane Foster in to the executive session?
Pardon me?
Do we need to invite Diane?
I'm actually gonna skip the executive session,
Okay.
thanks.
Okay.
Recording stopped.
Yes.